we today touch upon a very sensitive and a very important topic, which is about alimony maintenance and the child custody. Uh, we then segue on this series to have more esteemed panel come onto our series and they come and shed light on that. Without much ado, let's get going on our topic today. First, let's start with the topic of alimony slash maintenance. And I thought there was a lot of myths that is going around when people talk about or people fear about the amount of maintenance or alimony they need to pay in this entire processes. We thought it was very important for us to have a very open, educated, and empathetic discussions on this topic. And here we go on a further deep dive discussions on that. So Avnishji, like you always have been shedding some light on this topic, why don't we get going?
Misconceptions about maintenance. So one of the first and foremost misconception is that maintenance is awarded based on a fixed formula or a percentage, and in most of the cases, maintenance will be awarded to only one particular party, and maintenance will be quickly awarded.
And just
So.
because you ask somebody earns more, you
hmm,
can ask for more. Just because you need more, you will get more.
Let us tell you that this is not the case. Uh, every case is unique, and the courts have not come up with any fixed formula or any fixed understanding or any fixed percentage so far. So there have been some attempts here and there by various courts and Supreme Court as well. But see, each case is so unique that it is very difficult for a court to decide on a straight jacket formula about how much maintenance the asking party should be given. So, what courts do as of today is they first of all ask for affidavits that describe
The asset and
the
liabilities, you mean?
assets and liabilities of the parties, their bank statements, etc. And then they try to assess as to which party actually needs maintenance.
Or do they need?
So yes, and there are two types of maintenances. One is during the pendency, so that is called interim maintenance, and one is awarded after the final decision of the court. So in both these, assets and liabilities are carefully considered by the courts. And usually people think that just because one person is earning and the other is not, so it will make them by default eligible for maintenance or
Which is
a
also
very
not
high
true, isn't it?
maintenance. It is not true
Because
because courts also look at your earning capacity, not just your current. Because many people have this formula or have this strategy of manipulating courts by resigning from the job, or by transferring their properties to their relatives, and just to show that they have very less assets. But courts have an understanding or an assessment or a experienced judgment and it totally
and I
depends
think
on
that
the judge.
I think the
Yes.
reason why it becomes so very subjective is also the transparency in the
Mm.
documentation, in the actual facts that's being present by both the parties. I think it also depends on the court view of how many people are actually involved, because I think the maintenance amount starts to vary when it is not just the two parties, it's also when there are child involved, when one of the parties have aging parents involved. I think that's why deriving a formula out of how a maintenance should be paid is a very, very tricky situation. Includes so many nuances.
That interim maintenance has to be calculated from the day of the filing of the maintenance application. But even if it is so, the decision takes a lot of time. And after the decision, the implementation of the decision, the execution is also a very daunting task, because there is no quick relief for the delays in payment as well.
I think I think a lot of people have this myth, right? And hence we are talking on this topic is uh, that like the BMW case, right? whereas a hefty amount of money was asked for, a car was asked for. Then there was another case in Karnataka where a lady went on to ask a huge amount of money. But let's just make it clear to all and everybody on this hearing us today is that just because you ask for it, you don't get it, right? So be right, be factful, logical in the asks that you have. The more you are logical, more prudent, higher is your possibility to get what you asked for, and easier for one of the parties who is paying. It is easier for him to abide by the orders. And if you all would have realized, we have been constantly using the word parties because we also want to emphasize that it's not that a gender has to always pay. It could be any gender who has to pay, determined by the earning capabilities of both the parties. But an important reason or segue of why we also included the child custody in our discussion today is because we felt child, while it also has a huge impact on the decision making of maintenance versus alimony, which could be one time or uh, full and final settlement, child plays a huge role in determining that amount. And for that, we thought we should touch into that topic because we have seen a lot of parents not fighting on their rights for the child, right? Just like in a divorce petition, Avdesh said that you can file for an interim maintenance. One of the parties also has the right to ask for child visitation, joint custody, or full custody, or they can ask for the same via a separate case altogether, isn't it?
Absolutely, absolutely. I am just thinking that it is so ironical that the entire family law and the jurisprudence around it and the societal norm around it is in favor of welfare of children. And ironically, children are mostly used in these kind of maintenance battles, divorce battles. Child custody is sometimes used as an excuse to extract more. I'm sorry for my blunt words, but to get more alimony. So this kind of misuse of children not only harms the children but also future of the society. Yeah, and these silent sufferers, are mostly overlooked, and decisions about their life and their prospects are taken in such haste, such irresponsible manner, and it's really painful and disappointing.
So, to that effect,
Hmm.
we would like to highlight the rights of one of the parties, and we keep using the word one of the parties, is that one of the parties or both the parties have following rights, right? They could get a visitation order, they could get joint custody, or they could get full custody. In our humble submission, in either of the cases, please be cognizant of the child. If a joint custody is awarded or a full custody is awarded, look through it, see through it that the child has a stable base during the time when he has to be in the school or has to go to the school. See if one parent gets to see the child over the weekend. See if one of the parents get to see the child during winter or summer breaks. See if the child is able to spend time equally with both the parents. However, be the situation be, do not take away the right of the child or the right of the parent to meet their child, spend some quality time, so that the child grows well, the child is
Yes.
nurtured well, doesn't miss out on an opportunity to spend. And one other submission is a lot of parents initially might think it's okay for us to not see the child or do not know their rights on the child and just give up on the battle. Do not give up on the battle. If you have brought the child on earth, it's also the right, it's your responsibility to take care of the child, meet him, see him, talk to him, feel him, and take care of him, isn't it?
Yes, you are educated, you are mature, and so you have to be responsible for the child. So, as you rightly said, while negotiating or while mediating or while being in court about these things, you have to keep in mind that there should not be an order or there should not be a demand at least from your side, that affects the child's education in a harmful way. He should not be subjected to constant movements, relocations. It is not good for the child. Usually, in these cases, children are in their formative years. Their psychology is developing, affect children in ways you cannot even imagine.
So true.
So, responsibility is a must.
So true. I think in all of this, one thing that comes out loud and clear, and we have been talking about it all the while, is mediate.
Yes,
Mediation
yes.
is an empowerment.
Yes, because you
Mediate,
can't expect court to understand your family, your children better than yourselves,
exactly, exactly.
and so you have to be more responsible than courts, and you have to take a matured, conscious, pragmatic, wise decision, because the children are absolutely dependent. Their lives are dependent. You have lived your life to an extent, but for the children, the stakes are much higher.
Before we, you all enjoyed us bringing this
Yes,
very
I
sensitive.
would so you have to be very mindful of their needs and their rights. While you're fighting of your rights, their rights should be prominently placed in the entire scheme of things, and their rights of over both parents must be respected. Their right to education, life.
Hope you had some learning out of this. Like we always say, do like, subscribe, share your thoughts, comments for us to take them up at the end of the series and help you move ahead in life. With that,
Yes.
thank you, Sabakar and Subratri.
Have a nice day.